Historically, intellectual property rights were designed to protect the financial investments of publishing companies rather than authors' intellectual property rights. Current laws intend to protect the labor involved in the creation of a concept rather than protection of the work itself. Discovery of an idea is central in the application and defense of intellectual property ownership. Persons who discover or invent a previously unknown work are granted a patent by the United States Patent Office. Patent protection is important for development of new products and concepts. Patent holders own the financial rights to any products that are developed. The U.S. Constitution, Article 1, Section 8, Clause 8, provides protection for persons who hold copyrighted or patented materials. Congress passed the Trademark Law of 1881, which draws upon the U.S. Constitution Common Clause for regulation authority of trademarks. The Constitution's protection of authors' and inventors' rights was solely for the promotion of the arts and science and to provide some limited exceptions for the fair use in classroom settings. Fair use of copyrighted materials in traditional classrooms by instructors or students is articulated Teachers in a traditional classroom setting may use copyrighted works if a factor-driven fair use analysis was conducted and that certain criteria are met, which include the purpose and nature of the use, which includes commercial or nonprofit educational purposes, and the nature of the copyrighted work, the amount and substantiality of the portion that is used in the classroom in relationship to the copyrighted work as a whole. In other words, so long as a substantial part of the work is not used. The effect of the use upon the potential market or fair value of the copyrighted work. In a traditional setting, a teacher will always need to review fair use when replicating works for use in the class. Many campus libraries have obtained licenses that supersede the copyright laws, and we'll be talking about that in more depth later. Teachers may use parts or all of movies that have been made legally in the classroom for teaching purposes. That's covered under Copyright Law, Title 17, Section 110. Copyrighted photographs, graphs, maps, charts, and text may be displayed in the classroom as long as fair use criteria is met. Replication of web materials is not covered in Section 110. However, some argument has been made for fair use, and creators can be asked to grant permission for use. Live music can be streamed to a classroom, or hyperlinks to original works can be provided for student access. In the online classroom, instructors must appropriately apply the Section 110, which covers the use of visual materials in the classroom. Technology integration into the classroom was mandated by national accreditation associations and also state education associations. It is vital that teachers be informed about the current provisions of copyright law and the legal use of digital media in the classroom. It is important that instructors understand recent changes to the law and the implications that this can have on the use of digital media. The Technology, Education, and Copyright Harmonization Act, or the TEACH Act, was designed to update current copyright law in the United States, which had not kept up with the recent developments in technology. The TEACH Act specifically spells out the conditions under which educators can use digital media in the classroom without having to seek permission from the copyright holders or to pay royalties for the use of the media. The law was amended, Section 110 of the Copyright Law of 1978, to regulate teacher use of copyrighted digital media in the context of distant education programs at nonprofit institutions. The TEACH Act provisions do extend to the lawful use of copyrighted materials, but they also focus on the instructor activities that occur within the time limit or time period of the class. Educators and institutions must document their compliance with the TEACH Act. That is, they need to develop policies and procedures that specify how they are protecting copyright and how the use is allowed in the classroom. Teachers and institutions are not liable for the temporary copies that have been The TEACH Act significantly expands fair use provisions to distance education settings. Included in the allowance or expansion is the electronic display of materials. Instructors are also provided the ability to distribute materials to locations other than the traditional face-to-face setting. Instructors are allowed to digitize materials in order to transmit them. Storage is allowed for the duration of the class or the online activity. Non-dramatic The passage of the TEACH Act brought in a new era of digital rights management for educators and educational institutions. Digital rights management is a whole lot more than just copyright protection. There's an increasing demand for applications, and there is a need to secure, authenticate, and share many forms of digital media. The Digital Millennium Copyright Act, or the DMCA, is a United States copyright law. It involved the implementation of two treaties of the WIPO, or World Intellectual Property Organization. It provides measures that criminalize production and distribution of any technology, device, software, or any type of services that were designed to go around or circumvent controlled access to materials or works that are copyrighted. It makes it criminal to circumvent or go around an access control, whether or not the person actually infringes on a copyright itself. It also increased the penalties for infringement of copyright on the internet. The DMCA is divided into 5 titles. Title 1, the WIPO Copyright and Performance and Phonogram Treaty Implementation Act, amended U.S. copyright laws to be in compliance with a couple of WIPO copyright acts. There were 2 parts to these treaties. The first included works that were included in several U.S. copy prevention laws. The second part is also known as the DMCA provisions, and this, in essence, changed the legal remedies that a person had or an organization had for the circumvention of copy prevention systems, and it required that there be a analog video recorder for a specific form of copy prevention built in, and that each one have support for that. The section provided specific limits and exemptions for things such as government research and reverse engineering. There is no defense available for a fair use exemption for a person that would be teaching or doing research for legitimate use. Title II, the Online Copyright Infringement Liability Limitation Act of FILA, created a safe place for online service providers, OSPs, or internet service providers, ISPs. And that's against copyright infringement liability. Title III, Computer Maintenance Competition Assurance Act, provides protection for technicians who are working on a computer. If there's a need to make a temporary copy, then the technician would be covered under this act. Title IV contains a number of provisions. It clarifies the duties of the Copyright Act and added to them. It added Copyright Act abilities for broadcasters and provided some statutory licenses. Added provisions for distance learning, for libraries that who keep records of audio, and it also provided provisions for transfer of movie rights and collective bargaining. Title V, the Vessel Hull Design Protection Act, is an odd act that was included in this because apparently boat hull designs were not previously covered under any other copyright law, and they were included in this act. Main innovation that came from the DMSC is the exemption from liability, whether it be direct or indirect, of ISPs, Internet Service Providers, or OSPs, Organization Service Providers. Online instructors who wish to be compliant with the TEACH Act may be able to use copyrighted digital materials if they meet the following conditions. They have an original copy that was purchased from a copyrighted owner or somebody who was authorized to distribute it, or it was borrowed from a legal user, someone like a library. The, the second condition is that the amount that is used meets the fair use. It's consistent and it doesn't exceed the guidelines for the type of media that it is. The other part is that the material will be viewed or used in a live session, whether that be through a webcast, television, or face-to-face. The instructor should make sure that the display or materials can only be accessed by registered users, and that it is a controlled site which can only be accessed by someone with a user ID and it's password protected. The copyright owner has the right to prohibit people from using their material or digitizing it. If that is the case, then an instructor cannot use the materials. When an instructor wants to use some materials and there isn't already a digital Is there a need to write more laws and acts regarding the use of media? There's a growing body of literature that would say that the, the control of media has gotten out of hand. Overzealous copyright holders are asserting legal protections that were never intended in the DMCA. There is a clear gap between what the law actually provides and the reality of the practice. There is an ongoing conflictual relationship between what is perceived to be private rights to digital media and public interest. It is often said that possession is 9/10 of the law, and in the case of digital media, this is considered by content providers to be the truth. Content providers are charging fees for access to some material that should be public domain material. These are people such as libraries, archives, museums. All of these are charging access fees to public domain materials. People who want access rarely confront the content providers due to the hassle and the length of time that it would take and the cost that it would take to provide legal redress in this matter. The bottom line is that the public domain is diminished. There are less works then that are out there that should be out in the public domain but aren't. And for some people, the fees can be cost prohibitive. It, in a sense, becomes a skewed idea of what fair use laws should be. The DMCA, by providing an exception for online service providers, in a sense turned them into gatekeepers. OSPs are allowed to give a notice to a user that they need to take the material down because it infringes on a person's rights or the copyright holder's rights. This, in a sense, makes the OSPs judges, and it gives them the control over fair use. Many times the materials are not even under the OSP's jurisdiction. OSPs take this action in order to remove themselves from liability issues. This process adds another bureaucratic layer to what should be a simple process. The balance of control weighs heavily in favor of the private interest or the OSP rather than public or cultural use of materials. The DMCA criminalizes fair use activities. A person may have a right with the application of the Fair Use Act to use material in the classroom. However, OSPs or other copyright holders may decide that it themselves that it is not a fair use. In order to be preemptive in controlling the use of materials, organizations have developed encryption or uh, circumvention technologies that prevent people from copying or downloading files of digital materials. These measures are seemingly more cost effective for the content holder than endless legal battles. Increasingly disturbing are the one-click contracts that have been incorporated into much software and into almost every aspect of a person's life, from a cell phone to a Bluetooth object. The thing about digital consumers are that they are not the owners of the material that they are downloading. They are just having the right to use the material for a time limit. Potentially, a teacher who was using video clips and mixing them together for a class presentation could be guilty of a DMCA violation, when indeed the teacher is just intending to use those clips for educational purposes. Increasingly, consumers of public materials are losing rights to use those materials in the classroom. It is vital that teachers and students know their rights and know what the rules and laws are regarding the materials that they are intending to use. Should know the protocols for the classroom setting that they are using them for, or that they are accessing them. Instructors and students alike have responsibilities for the media that they use in a classroom. Instructors should know the TEACH Act and the DMC Act intimately. They should know the applications of each one of these acts for every media that they use in the classroom. They should also follow the protocols that are involved with each media. It can be difficult to find out sometimes whether there's a copyright holder. The answer to that is don't use it. Find something else to use. Ensure that all materials that you use in the classroom are protected with security measures. Implement passwords. Only allow access to students with an ID and protection. Students need to follow protocols that are in place for the use of media within the classroom. These protocols should be clearly written and stated by the instructor. Students should understand the TEACH Act and the DMC Act also for all media that they use within a classroom. You need to follow protocols for copyright circumvention, because it could end up with a criminal charge on them if they don't follow, and they should not share their passwords. Educators and educational organizations should create clear policies that provide broad coverage. A smaller policy but broader that policy that requires compliance to the DMCA and TEACH Act from both students and teachers. That can be effective in limiting the initial violations. Provide guidance for the legal use of materials online. Guide students to the Creative Commons site, which will provide immense materials for online use. Teach students and teachers how to use search tools to help find usable materials. Promote the Creative Commons to both teachers and students. Pay attention to what's going on in the classroom. While it is easier to use materials online with the use of the TEACH Act and the DMCA, it does not necessarily make it easier to share files or other documents. Make sure you realize that you could be making a copyright violation if you share PDF copies. Make sure that you know about open source software licensing. Technical staff should make notes of the software that is being used. Administrators should know what the limitations are or the potential copyright litigation issues. Sometimes staff leave that obtain the original license on a software and they no longer work for the school. This could provide a basis for litigation in the future. Understand what the rights are for making works in-house, that is remixes, and have a default policy with a clause that gives you the ability to lock down a piece of work if you're given notice. If you have materials that have been developed specifically by educational marketers and companies, do not copy or make substantial copies of those books, software, posters, or anything like that. That's not considered fair use. And the school, the teacher, or the district could be sued, prosecuted. The changes that I would make to the DMCA and TEACH Act would involve making it easier for teachers and students to access materials of any kind, whether they be audio or files or PDFs, art. I would say the initial reasoning for there being exceptions to copyright laws was for this purpose, to provide education to students and access to materials. So I would suggest decriminalizing some parts of this and providing a process for people who are using materials to confront content holders on their infringement claims. As far as control, that's the same thing. Provide more control to the licensee of media. In other words, uh, remove some of the infringement uh, and circumvention technologies on materials, or provide a alternative that can be used in the classroom, much as is used by libraries for, say, articles and that type of thing, but provide a specific avenue um, for the downloading of materials. And I guess that gets back to access. Provide the tools um, that are developed primarily for educational purposes. I would suggest that the DMCA and Teach Act uh, put money behind their acts. In other words, research tools that can be used in the online classroom, and keep pumping dollars into those efforts to keep pace with technological changes uh, in the internet and in new mediums. Research new mediums as soon as they come out. Don't wait for copyright legislation or prosecution to hit the court. Be proactive about it. This will ensure that students have access to the newest media as soon as it comes out.